Hi folks, and welcome back to Contract Law. This video series is on the Australian consumer law. And as you can see from our Prezi this week, the Australian consumer law is housed in the Competition and Consumer Act. And there are four main areas in which the Australian consumer law cuts across contract law and so is of interest for our particular unit. The first of those we'll cover today is consumer guarantees. And then we'll look at unfair contracts. And in later video series, we'll have a look at unconscionable conduct and misleading or deceptive conduct. First of all, what we need to do though is have a little look at the Competition and Consumer Act, how it's set up, how it operates legislatively speaking, and what the main provisions are for us of interest in this video series. Now, the first thing I want to say about the Competition and Consumer Act is really that it's quite a remarkable piece of legislation. It's been a long time coming, a long time in the making, and what we have at this point is one of the strongest and best protections for consumers and protections against anti-competitive conduct that you'll see pretty much anywhere in the world. It is globally recognised as a very effective piece of legislation, and it's quite interesting that you get to jump in and wallow around in it, so to speak, early on in your law degree, because it is something that you should become very, very familiar. As I said, there are some areas of this legislation that are relevant for contract law. There are other areas of the legislation that are relevant for corporations law, for competition law, and so it is a piece of legislation you'll get to know very, very well. Previously, even before we had the Trade Practices Act in 1974 that came on board, we had a series of, should I say, a mishmash of sometimes effective, sometimes ineffective state legislation. Most of them were called the Fair Trading Acts, that all operated in slightly different ways. So it meant that if you were a company that traded across state lines, then you're going to be subject to a multitude of different pieces of legislation in terms of, for our purposes, your contracts and how you dealt with consumers. And then you had the entry of the Trade Practices Act on the scene, a very well designed piece of legislation and very effective. Still, the bulk of it forms the basis of our Competition and Consumer Act. However, what it really did in '74 was it kind of just overlaid this federal layer of legislation on top of the various different hodgepodge pieces of state legislation. And there wasn't one holistic approach to, for our purposes, contracts, how businesses dealt with consumers. And so there was this great series of talk fests that happened in the lead up to the drafting and eventual rollout of the legislation as we have it now, where the states, got on board with the government in talks and said, look, we really have to do something about this. We need a holistic approach to particularly protection of consumers. And, if you've done statutory interpretation, you'll know the states are quite jealous about their legislative powers. They didn't necessarily want to cede all of their legislative power to the Commonwealth in this area. The Commonwealth can only legislate on a certain number of things, and so they agreed with this cooperative approach where what we would do is implement a grand piece of federal legislation, and then you get this mirroring, beautifully consistent state legislation that would kind of hang off it and operate in the state sphere. And that's what we have now, a very cohesive, strong and effective consumer protection regime. So in order to understand how the regime works, we really need to first have a quick recap of federal legislative power and how the states and the federal government kind of work in with each other here and why the legislation does what it does. So if you cast your mind back to intro and statutory interpretation, you remember that when Australia was colonised, we had the 6 self-governing colonies, Queensland, New South Wales, Victoria, Tasmania, South Australia, Western Australia, and they quite happily made all the various different laws that applied to their colonies. And then upon federation, we had the establishment of the bicameral parliament, and we had federal law-making powers being created. We had the Commonwealth of Australia Constitution Act being passed, and that legislation does some very specific things. I've taken you to the Constitution because it's fairly important that you understand what it does. But if you have a look at section 51, it sets out the legislative powers of the federal government. And in section 51, you will see that the federal parliament only has power to legislate on these particular heads. Okay, the parliament shall have power to make laws for peace, order, and good government of the Commonwealth with respect to only these things. Okay, this is exhaustive. Trade and commerce, tax, bounties, borrowing money, post, telegraph, and so on. And then we come right down to head of power number 20, and that is foreign corporations and trading or financial corporations formed within the limits of the Commonwealth. Now, there's a couple of other ones that are relevant for us, but the main one for the purposes of the Competition and Consumer Act is section 51(20), the head of power of trading and financial corporations formed within the limits of the Commonwealth. So you might think that all of the times that you see the word person then in the Competition and Consumer Act can only really just refer to companies, because there are 2 types of persons, aren't there, in terms of legislation. There are corporate persons and there are natural persons. So you might think that the term person in the legislation can only really constitutionally refer to companies. However, the word person is used for a reason, and that is because the federal parliament could rely on other heads of constitutional power to broaden out the reach of the Competition and Consumer Act and Australian consumer law. And the conduct of natural persons can be caught constitutionally through sections 6, sub 2, sub 3 and sub 3A of the Competition and Consumer Act, which basically says that if the conduct involves interstate or overseas trade, or trade between states and territories, supply to the Commonwealth, or conduct that involves the use of post, telegraph, telephone, radio or TV broadcasts, if the conduct of natural persons involves those kinds of things, then the Competition and Consumer Act, ACL, can actually reach out and grab those naughty people as much as if they were companies. So that is the metes and bounds, if you will, of the federal legislation. How then do we operate at a state level to catch all those naughty natural persons that do things otherwise? Well, as I said, the state legislation mirrors the federal legislation, operating within each state jurisdiction. And because the states are not fettered by this series of federal heads of power, because the states can legislate pretty much about anything that happens within the boundaries of their state, then they can quite happily use the word person in the state legislation to catch anybody. So what you have is this really cohesive, rather formidable set of legislative instruments that protect consumers from pretty much every angle. If you're looking at companies, particularly where companies are operating in an cross-border, cross-state fashion, no problem. You can get them with the Commonwealth legislation. If you're looking at naughty natural persons or companies, but they're just operating within the state boundaries, you can catch them with the state legislation or territory legislation. So there's very little in the way of loopholes that will enable people to get out of or away from this legislation. And there are also, as we will see, a number of mechanisms in the legislation itself that don't allow you to get out of the reach of the legislation itself. But we have this whole question, how exactly does a company become liable? And as you can imagine, when a company is just basically a legal fiction, it is not a natural person, it is an incorporated entity. And because it's an incorporated entity, the only way that it can do things, make decisions, make investments, do business, is through its directors, servants, and agents. It has to have eyes, it has to have hands, ears, it has to be able to conduct itself. The way it does that is through natural people. And the company will be liable, vicariously liable, for the conduct of its peeps. Under section 139B sub 2, the Competition and Consumer Act deems the conduct of a person acting on behalf of a company to be the conduct of the company. So if director, servant, employee, agent breaches the legislation, breaches, for example, what we're most interested in, which is the Australian consumer law, then that company will also engage in that breach. That is how companies are liable. However, having said that, it doesn't mean that the person that has caused the company to engage in the breach of the ACL is going to get off scot-free. Oh, no, no, no. Our legislation is far scarier than that. You may well find that if that is the kind of conduct you've engaged in, then you personally may find yourself liable for either compensation under 237 or damages under 236 if you have been an accessory to a breach of the ACL. And people that have been involved in a contravention, okay, even if they're not primarily liable, if they've been involved in the contravention somehow, they can either be made to pay damages or compensation. So if you've done the usual accessorial kind of naughty things, like you've aided, abetted, counselled, procured a breach of the ACL, if you've induced it by threats or promises, if you've been either directly or indirectly knowingly concerned in or somehow party to, or you've conspired with other people to breach the ACL, then again you may find yourself personally liable. So let's sum it all up. We know that we have Commonwealth legislation called the Competition and Consumer Act. Schedule 2 of that Act is the Australian Consumer Law. We know that the Australian Consumer Law applies to companies and sometimes to individuals under the Commonwealth legislation. We know that we have in each state and territory a mirror version of the Australian Consumer Law that's been imported into every state and territory and applies there. So we have good network of coverage of consumer protection. We know now that companies are liable because of the conduct of their people, their directors, servants, agents, employees. And we also now know that if you cause a company, or anyone else for that matter, to engage in a breach of the ACL, then you might find yourself liable as an accessory. Okay, so individuals might be liable primarily, or they might be liable as an accessory. Okay, so they are the provisions and the general way that the Australian Consumer Law has been enacted and the way it operates in Australia. The main provisions that we need to know in terms of the Australian consumer law are consumer guarantees, unfair contract terms, unconscionable conduct, and misleading or deceptive conduct. As I said at the very beginning of this video, we'll be covering unconscionable conduct and misleading or deceptive conduct elsewhere. So that means our next video will deal with consumer guarantees. And so until next time, bye for now.